In this lecture, we would be dealing with fundamental rights. The fundamental rights in the Constitution of India form the enforceable minimum guarantees available to all citizens of India. In certain cases, the rights are not available to citizens alone, but are also available to non-citizens. Though mostly negatively worded, the fundamental rights have not only acted as limitation on governmental action, but have also been interpreted by the courts in India to include positive obligations on the government. Let us now look at why fundamental rights are important and why are they often referred to as the Magna Carta of the Constitution of India. In the Indian society, the only institution which can legitimately employ coercive force is the Government of India. Government of India also enjoys vast powers by the virtue of having regular tax revenues, control of various assets, and exclusive control over foreign policy. This vast scope of power makes the misuse of these powers possible. Fundamental rights stand in way of such possibility becoming a reality. Fundamental rights circumscribe and limit the powers of the government and lay down explicit limitations which may not be transgressed by the government. We would now delve a bit deeper into the precise rights guaranteed under the Constitution. Let me make one thing clear at this stage. Indian Constitution grants rights other than fundamental rights. An example is the right to vote. Another example is the right to property. But they are not the same as the fundamental rights. Fundamental rights are those rights which are considered inviolable by the constitution makers. They are sacrosanct. They are enforceable through writs by the constitutional courts, the high courts and the supreme courts. Thus, the fundamental rights are a higher level of rights than ordinary rights under the Constitution of India. Let us now look at some of the rights granted under the Constitution of India. Firstly, we will look at the right to equality. Fundamental and inviolable equality of all human beings forms the basis of rule of law. The Constitution of India grants to every person equality before law and equal protection of law. The Constitution of India, therefore, seeks to treat all people in India at the same level. Right to equality tries to do away with discrimination. It provides for equal access to public places like shops, hotels, places of entertainment, wells, bathing ghats, and places of worship. There cannot be any discrimination in this access on the basis of caste, creed, color, sex, religion, or place of birth. It also prohibits any discrimination in public employment on any of the above mentioned basis. This right is very important because our society is not a society known for its treatment of people equally. India was a severely hierarchized society. India was rife with separate classes, higher and lower castes, and therefore the right to equality was a watershed right in Indian history of rights. This right has been interpreted broadly by the courts in India to include not only the literal words but the spirit of equality. The courts have expanded the meaning of this right by laying down through various judgments that not only procedural but substantive equality is what the Constitution establishes. Let this be made clear at this stage that the Constitution does not lay down that regardless of their circumstances all people should be treated alike. What the Constitution does lay down is that people in similar circumstances should be treated similarly. Thus, courts have upheld dissimilar provisions for different sections of people, provided there is a reasonable nexus between the end sought to be achieved and the classification so made itself is based on intelligible differentia. Thus, you cannot justify a differentiation based on age when the real reason when the differentiation is based actually on sex. Thus, there has to be a connection between what is sought to be achieved and the means for the same. Following from this logic and recognizing the gross injustice which the oppressed classes were subjected to in historical period in Indian society, the Indian constitution makers provided for affirmative action policies giving special leniency and competitive advantage to people from certain sections in appointment with the government and access to educational opportunity. In common parlance, this system is known as the reservation system. Another facet of the right to equality is the abolition of untouchability. Article 17 abolishes untouchability. This section was operationalized through the Civil Rights Act and was further supplemented through legislative enactments such as Prevention of Atrocities Act. It is often argued that the abolition of untouchability has been restricted only to the pages of law books, and it continues to be practiced in the Indian society. We must understand that it was a primary objective of the constitution makers to ensure that the so-called scheduled castes or the Dalits were given the greatest extent of rights and greatest justice was given to them, as it was often felt that they had been meted out the harshest injustice for centuries and for generations. The reservation system sought to put an end to that, and by positive discrimination to bring them at par with the other sections of Indian society. Thus, we find special provisions made for scheduled caste, scheduled tribes and backward classes so that the injustices done to them over generations can be done away with. The courts have held that these are not violations of the right to equality, because equality means equal treatment of people in equal circumstances. Article 18 stresses another facet of equality. At the time of independence, various titles were awarded to people. These titles included titles such as Maharaja, Sir, and others. There were other titles which were hereditary. Article 18 abolishes all titles except military and academic titles. You must remember that titles such as Padma Vibhushan, Padma Shri, etc. are not titles. They are the recognition of great contributions of certain individuals. However, they may also not be used as titles. After having seen these facets of equality, let us now move on to the second set of rights, the right to freedom. The right to freedom seeks to encapsulate a very broad set of rights. The right to freedom forms the second group of rights under the Constitution of India. They encompass a wide variety of rights under their cloak. Along with the right to equality, it forms the core of democratic society. Let us examine the articles under rights to freedom individually. Article 19 provides 6 freedoms. The first is the freedom of speech and expression, thereby enabling both a democratic polity and a culture of open intellectual exchange. It is this freedom which enables free and unhindered exchange of information. Though not expressly mentioned, the Supreme Court has held that the freedom of press is also a part of the freedom of speech and expression. The freedom of speech and expression is not absolute, but stands restricted reasonably in the interest of public order, security of state, and decency. The second freedom guaranteed under Article 19 is the freedom to assemble peacefully without arms. This freedom is again a necessary incident of a society which seeks free and fair exchange of information and a democratic order. The third freedom guaranteed under Article 19 is freedom to form associations or unions on which the state can impose reasonable restrictions. The fourth freedom guaranteed under Article 19 is the freedom to move freely throughout the territory of India, subject to reasonable restrictions again. The fifth freedom under this article is the freedom to reside and settle in any part of India. Like other freedoms, this freedom is also subject to reasonable restriction. These restrictions include the special case of the state of Jammu and Kashmir, wherein a citizen from a state other than Jammu and Kashmir may not purchase land, and also a Kashmiri woman who marries an outsider may not purchase land. Protection is sought to be provided to scheduled castes also to ensure that indigenous and tribal people are not exploited or forced against their will to part with their land resources. The sixth and final freedom guaranteed under Article 19 is the freedom to practice any profession. You might be thinking, if as an Indian citizen you are entitled to freely choose your profession, why do you need to do degrees to get the same? Even this right is subject to reasonable restrictions, and only those suitable for particular jobs can be appointed to. Article 20 provides a very important set of rights. These rights grant protection to an individual in respect of conviction for offences. The right has three components. Firstly, no individual may be awarded punishment which exceeds the punishment which would have been awarded at the time of commission of the crime. Thus, this article provides a safeguard against retrospective operation of laws. Secondly, this article provides protection against self-incrimination. Self-incrimination pertains to being a witness against oneself. This article saves individuals from being compelled to give witness against oneself. This assumes particular importance, as if witness against oneself was admissible, prosecuting agencies such as the police, CBI and others could force individuals to confess to crimes which they may not have committed. The persons affected the most by this would be the lowest, downtrodden sections of society. The third right provided under this article protects an individual from being tried twice for the same offence. This is called a protection against double jeopardy. To give an example, let's assume X has been tried and found innocent of committing a crime. In such a situation, it would not be constitutionally valid to try him for the same offence again and again. Article 21 states in very simple terms that no person shall be deprived of his life or personal liberty except according to procedure established by law. Though a short article, it contains the seeds of much modern constitutional welfare jurisprudence. The words life and personal liberty have been given the widest interpretation by the courts. To quote, life is not mere animal existence or survival. It would include the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. The expression personal liberty covers a wide variety of rights which go to constitute the personal liberties of a man other than those which are already included in Article 19. The courts are inclined to give the widest amplitude to the expression. On account of the liberal interpretation, Article 21 has now come to be invoked almost as a residuary right, even to the extent which the founding fathers never dreamt of. The courts have now included, among others, the following rights under Article 21. First, right not to be subjected to bonded labour. Second, right to livelihood by means which are not illegal, immoral, or opposed to public policy. Third, right to decent environment. Fourth, right to shelter. Fifth, right to travel abroad. Sixth, right to speedy trial. Seventh, right to legal aid. As I am recounting these rights, you can see that they do not find a mention anywhere in the text of the article. However, they themselves make sure that a person gets to lead a meaningful and complete life. Next, the right to privacy. Then, the right against solitary confinement, right against bars and fetters, right against handcuffing, right against delayed execution, right against custodial violence, right to education, right to pure drinking water, right to good roads, right to reputation, right to freedom from noise pollution. As we proceed through this course, we would have much greater opportunity to understand the full scope of this article, as this article can be said to be the basis of much modern welfare jurisprudence also. The most recent addition and the newest entrant to the fold of the fundamental rights is Article 21A, the right to education. In pursuance of this right to education, the Right to Education Act has also been passed. The right to education basically operationalizes one of the directive principles of state policy which sought to give universal education. This right shows the Indian state's willingness and the now existent capacity to provide education to the largest and the widest section and all the people, all the children between the ages 6 to 14. This is a great development in India's constitutional history, and it is hoped that in the times to come, India would rid itself of the plight of ignorance. The next right is the right against exploitation. Indian society, because of certain historical realities, was burdened with people who could not lead meaningful lives merely because they were born in certain castes, merely because tradition forced them to live a life of servitude and a life in which they could not lead, they could not pursue, they could not choose an occupation of their choice. A society where individuals are exploited and forced to live a life of want cannot succeed. Article 23 and Article 24 provide right to individuals against exploitation. Articles 23 and 24 specifically prohibit two such forms of exploitation. The first is begar or forced labor, wherein the person exerting himself is either not paid at all or paid such meager amounts which mean practically nothing. The system of begar had persisted in Indian society due to various social, economic and cultural reasons. However, our further exploration in the coming chapters would make it clear that this battle is far from won, and many Indians are still forced to eke out a living from nothing due to practices like begar. For a full discussion and extent of this problem, you might want to refer to the Supreme Court judgment in the Bandhua Mukti Morcha case. Begar is a reality for many Indians even now because of the extensive situation, the extensive presence of unemployment in India. It is but natural that many people find themselves forced to do things which they would much rather not do. It is therefore imperative that we improve the existing conditions of employment in India, that we make employment much more visible, that we make employment possible for those people who have not had the best of education, and so that they are not forced to perform work which they would not do otherwise than in state of extreme want. The second part of this article is the right against trafficking in human beings. However, it needs to be stated that this right has gotten attention again and again for the wrong reasons. India continues to be amongst the prime locations for human trafficking in the world. We will look at this issue in greater detail in one of the case studies in later parts of this course. The next fundamental right is the right to freedom of religion. Indian Constitution guarantees to everyone the freedom of religion. These rights ensure that everyone has the freedom of faith and worship, and also that all religions are treated equally. Why is a right to freedom of religion important? Many people practice religion. They never had any such right before. The reason is that India seeks to be a secular country, and India's secularism is sui generis. It's of its own type. Indian state does not seek to favor any religion over others. It seeks to be equal to all religions, and all people have a right to pursue their own religious belief. This right is extremely important if we remember at the time of India's independence, the partition of India on religious lines happened. This article exists in the constitution to remind everyone that India does not believe in religious bigotry. Indians believe that all religions are equally good and anyone and everyone has a right to pursue the religion of their choice and to pursue their faith to the fullest extent. Indian secularism, unlike Western secularism, does not believe in the strict separation of church and state. Instead, Indian secularism bases itself on equal treatment of all religions. The reason behind this is the eclectic and pervasive influence of religion on Indian society. It must also be remembered that in India, the government can intervene in religious matters to root out certain social evils. Previously, the government has banned various religiously sanctioned practices which include sati, bigamy and human sacrifice. Thus, Indian government is not subservient to any religious sect. It is not subservient to all religious sects also. In India, the government stands besides religion. The government stands along with religion. Neither subsumes another, but the government has the right to alter all such practices which might be injurious to society as a whole. Now, let us look at the other set of rights, which are the cultural and educational rights. The sheer diversity and range of Indian culture make it imperative that various minorities, including religious and linguistic minorities, be given the right to conserve and propagate their language and culture. Thus, Indian Constitution grants special rights to linguistic, cultural and religious minorities to conserve and propagate their language, culture or religion. This is a reflection of the belief of the Indian Constitution makers that India's strength lies in its diversity and plurality. These rights include the rights of minorities to set up their own educational institutions. These also include a right to practice, profess and propagate their own religion. These rights allow minorities to not only conserve but also to continue their own linguistic or religious diversity. Various colleges, educational institutions have been formed by minorities which continue to impart education to members of these particular communities as well as to people of outside communities. It must be understood that the minority status is not nationwide but differs from state to state. Thus, there might be states wherein communities which are a majority in the rest of the country might be minorities. Finally, we reach the most important part of these fundamental rights. You might ask, why would I choose any one right to be called the most important? And my answer would be, it is because this right makes all other rights possible. I am talking about the right enshrined in Article 32, which is the right to constitutional remedies. Under Article 32, which Dr. Bhimrao Ambedkar considered the heart and soul of the Constitution, there exists a right available to all those whose fundamental rights have been violated to approach a court of law and seek as a relief that their rights be implemented. Without Article 32, fundamental rights would remain mere words without any effect. However, Article 32 makes it incumbent upon the High Courts and Supreme Court that any violation of fundamental rights is remedied post haste. The courts can issue orders and give directives to the government for the enforcement of rights. The courts can issue writs, which include writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari. The High Court has much wider powers of issuing writs than Supreme Court, as the jurisdiction of Supreme Court is limited only to the 5 writs mentioned above, whereas the High Courts under Article 226 may issue writs of other nature also. This writ jurisdiction of the courts has been used widely by various social welfare groups to ensure that the rights of those who cannot by themselves approach the courts are enforced and they get the reliefs which they should have gotten because of the availability of fundamental rights to these people. Thus, we see that fundamental rights seek to provide a level playing field, a certain minimum guarantee of rights to all people who inhabit India. We have seen that right to equality, right to freedom, right against exploitation, and cultural and educational rights, along with the right to constitutional remedies, form the very core of Indian constitutional guarantees. These rights make sure that people get a minimum decent standard of living. These rights make sure that no one can be exploited, and most importantly, these rights make sure that the state does not favor any particular community, group, or individual. Therefore, we see that the fundamental rights are the first step towards a welfare state, and a state which seeks to improve the lives of the individuals which inhabit it.